na madiwani wakereketwa CCM, weka bendera juu. Basi weka kama unapenda na Mwinyi mikono juu. Weka kama unapenda na Mwinyi mikono juu. Weka kama unapenda na Mwinyi mikono juu. Basi tena peperusha bendera. Wanakubendera, wanakubendera. Sijaona bendera, wanakubendera. Sijaona bendera. Wanakuwa Zanzibar, weka mifuko juu hiyo. Waka DJ Tito 2025 tunakwenda na Mwinyi. Asante, weka. Basi tena oi baba. Wanakuwa masa. Weka. Aya wanakumkoa api na mbona siwaoni. Weza Zibari mkoa api na mbona siwaoni. Nimemisi wanakupiga kidogo. Nimemisi wanakupiga kidogo. Tito wena nungwi mikono juu kidogo. Tito we wanungwi mikono juu kidogo. Basi we kama unapenda na Mwinyi mikono juu. We kama unapenda na baba mikono juu. We kama unapenda na Mwinyi mikono juu. We kama unapenda na Mwinyi mikono juu. We kama unapenda na baba mikono juu. Weka mikono juu tupe salamu mheshimiwa Mwinyi. Weka salamu. Tito. Nasema namtaka nani? Namtaka Mwinyi. Namtaka nani? Nataka nani?
Kwa moyo wote wa shukrani, siku zote TLS tunafanya mchango wako mkubwa.
Nataka nani?
Kwa ukitusaidia.
Nataka nani? Basi we kama unapenda na Mwinyi mikono juu. We kama unapenda na baba mikono juu. We kama unapenda Samia mikono juu. We kama unapenda na baba mikono juu. We kama unapenda na baba mikono juu. Waluka Kimasai, waluka Kimasai, waluka Kimasai, waluka Kimasai, waluka Kimasai, waluka Kimasai, waluka Kimasai. UWT! UWT sijaona UWT. Tunyanyuke kwenye viti. Tunyanyuke kwenye viti UWT. Sijaona umoja wa vijana, sijaona umoja wa wazazi. Weka. Haya jamani, mama huyo shifu wakaya, mama huyo Nesi Samia, mama huyo mmemuona, mama huyo UWT peleka
sababu ndio sehemu pekee ambayo unaweza mkakutana na kuweza kujadiliana na kuweza kubadilishana uzoefu. Mnajadiliana mambo ya kitaifa, lakini mnajadiliana hata masuala yenu wenyewe binafsi. Sasa kunapokuwa hamna jukwaa, ikate programu ianze, inakuwa ni changamoto kubwa. Lakini kikubwa ni wapongeze sana washiriki wote. Kwenye screen inaonekana kwa kweli wadau
sasa hivi inasoma sauti kama naisikia. Singeliwisha
Novemba tukiwa Arusha, ilikuwa ni changamoto kubwa sana. Tunajaribu kutafuta vijana wetu wana sheria, mbona hawajahudhuria kwenye masuala makubwa ya katiba, majadiliano ya katiba, lakini huoni hata mtu yeyote. Yani katika vijana ambao tunao zaidi ya 6 au 7, unakuta kuna vijana 4, 5 wamehudhuria. Sasa maendeleo yenu ya vijana, maendeleo ya TLS hayawezi yakaja kama vijana hamhudhurii na kuweza kujadiliana mambo makubwa kwa ajili ya ujenzi wa TLS, lakini mambo makubwa kwa ajili ya ujenzi wa taifa letu. Lakini vingine ni kuwapongeza pia hata ambao wako online, ambao wamechukua muda wao wa kuweza kuhakikisha kwamba wanahudhuria. Na niseme tu kwamba waheshimiwa vijana mawakili, kama TLS tutaendelea kuwashukuru, na kwa sababu mmekuwa ni chachu kubwa. Kuna wakati mwingine mambo yanaweza kawa hayaendi vizuri, au kuna maamuzi pengine tumefanya ambayo sio kwa ajili ya maslahi ya wanachama, lakini nyinyi mmekuwa mkitoka mbele na kuweza kuchallenge mkichallenge ile ndio inayofanya sasa taasisi kuwa hai. Kwa hiyo leo niwatakie kila lililo la heri mnapoenda kujadiliana namna gani nyinyi kama vijana mnaweza kuwa watetezi wa haki za kidijitali, lakini namna gani nyinyi kama vijana mnaweza mkahakikisha mnasimamia na kulinda utawala wa sheria katika nchi yetu, na hasa kipindi hiki ambacho tunaelekea kwenye uchaguzi mkuu. Sasa nyinyi ndio tegemeo la TLS, lakini nyinyi kama vijana ndio tegemeo kubwa sana la taifa letu, la kutoa hata elimu kwa vijana wenzetu wasije wakavunja amani. Tunawezaje kuweka mikakati mbalimbali ambayo inaweza ikasaidia pale ambapo kunakuwa na changamoto, zile changamoto tukazimaliza kwa njia ya majadiliano. Kwa hiyo ni fursa yenu nyinyi vijana kuweza kuja na mikakati, kujadiliana ambayo yanaweza yakafanyika katika nchi yetu na kuhakikisha kwamba nchi yetu inakuwa iko salama, nchi yetu inakuwa iko na amani, lakini kikubwa zaidi nchi yetu na vyombo ambavyo vimekasimiwa kuhakikisha kwamba utawala wa sheria unazingatiwa, basi vinaweza kufanya wajibu wake. Bila kupoteza muda, najua mnayo mambo mengi sana ya kuweza kujadiliana kwa siku ya leo. Naomba nirudi kwako mwenyekiti wetu wa vijana wa AYL ili muweze kuendelea. Niwatakie kila lililo la heri. Asante sana.
Okay, nashukuru sana Madam VP, na point taken ni kwamba vijana na association tuna role kubwa kwenye TLS na kwenye nchi pia. Kwa hiyo tuwe na participatory approach na inclusivity. Thank you so much Madam VP. Tunashukuru sana na kwa upendo wako pia, kwa sababu you have been with us all over. You have been supporting the event. We are indebted. We appreciate it so much. And please give a round of applause to Madam VP. Thank you so much. Thank you so much, Madam VP. Now let me take my last duty in this podium to invite our retired judge, Dr. Robert Vincent Makaramba, for the keynote address. And while Dr. Makaramba will be coming here to address, I urge you, or I request you all to stand up and to clap while he will be marching forward to make his keynote address. Thank you so much. Welcome, Dr. Vincent Makaramba, retired judge. Please stand up.
Asante bwana Ukashu. Kaeni. Haya mambo ya kulazimishana kusimama ni ya CCM. Good morning. I'm supposed to make a keynote address. You know, a keynote address means a note which will open the door to the discussion. Now, I've been given a very specific topic, but before I begin, let me thank the Almighty God for bestowing us with good health and for enabling us to meet here today, and with the great zeal and commitment. I thank you all for attending in great numbers. But I also thank the organizers and specifically the leadership of the Association of Young Lawyers, the chairperson and the secretary. With that, I must say that all the protocols, I subscribe to them. I don't have to repeat each and everything because I may miss some word names and then people will feel bad. Now, I've been asked to speak on democracy and technology, navigating challenges and opportunities in Tanzania. The good thing is nobody knows the definition of digital democracy because it's an elusive term, it's very new, And excuse the good thing about lawyers, they tend to define everything. But I think if you ask members in this conference, what is digital democracy? They will start from a technological point of view. But digital democracy is a new concept. And of course, we have not been able to get a clear definition, but actually we have some of the elements. Some people call it e-democracy because everything now is e, or sometimes they call it teledemocracy, which means it's a democracy where many people participate in the decision making. You know, our democracy, which we copied from our colonizers, what we call liberal democracy, although we didn't copy each and every element. And actually, that's what is in our constitution. Our constitution speaks about Tanzania is a democratic, secular, and socialist state. Don't worry about the socialist. And also it says it adheres to multi-party democracy, and also it abides by the principles of democracy. Now, if you look very closely at all this, it means the physical representation of some of our leaders we elect every 5 years. And once we elect them, we forget about what they are doing wherever we send them to do. We meet again after 5 years. We celebrate in different ways. The leaders celebrate to go and renew their tenure. For us, we are celebrating for not having achieved anything. Now, with the teledemocracy, and we have seen it, it always includes the young generation. When I say the young generation, when you look at our constitution, the liberal democracy which we copied from the West includes only people who are 18 years and above. Now we ask ourselves, who represents those who are below 18? And if you look even at the qualifications for being a leader in Tanzania, you cannot be a president if you are not above 41. But surprisingly, our first president was a president when he was 32 years. So we have a tendency of making the law to fit the events. When they thought someone young is going to be president, they made the law to prevent him from running. And that is what we do with liberal. Now, with the digital democracy, it's very difficult to control the participants. But the other thing we have is we don't really have rules for the game on how people can participate in the teledemocracy. If you were following events in Kenya during the GNC issues, we could see very clearly that there were no rules, but the leaders made a mistake of not listening to the GNC. Instead, they unleashed massive violence against them, and things got worse as it was continuing. Many people lost their lives. The other example of teledemocracy is what happened in the Arab world. And most leaders fear teledemocracy because you don't need a specific place to assemble. In our traditional democracy, you need to meet at a place, and you have to ask for permission to meet at that place. With teledemocracy, you don't need that kind of permission. You meet online, and that is what actually can make a lot of people participate, and you share ideas. But the other thing is it's very difficult to have a leader in a teledemocracy because everybody has power so long as you can access the information. So that's, again, it goes against what we call the traditional democracy, that there must be a leader with an agenda. So, but these things can be sorted out. Now, if you look at our environment, the question we ask ourselves, has our legal environment gotten ready to allow teledemocracy? In my view, we are not yet ready. And I'll share with you some few examples. With the teledemocracy, you have unhindered access to public information. But in Tanzania, we have Access to Information Act, which actually, in a way, prevents you from accessing public information easily. So you have to make a lot of applications. But with teledemocracy, you must access information. Now, if you cannot access democracy, the information, you cannot make informed decisions. The other thing is the licensing aspect. In Tanzania, you have to be licensed to speak. Otherwise, if you speak in public without a license, that's a criminal offense. You need permission to assemble. But with the teledemocracy, you don't need all those things. Yeah? And the timeline, you can meet at any time of the day, even at midnight. And of course, those people who control the meetings, the only thing they can do is to use criminal laws. The best thing they can do is to block the platforms. And in Tanzania, the person who does that is the Tanzania Communication Regulatory Authority. They have those online regulation, which everybody is making a noise about them. And actually, it's a very interesting regulation because you regulate yourself. If you fail, it's a criminal offense. So TCRI will deal with you. So you regulate yourself, for example, they will tell you, don't publish prohibited information or content. If you publish it, you have to remove it within 45 hours. If you don't, now you commit a criminal offense. So there is this growing aspect of criminalization of the democratic principles, because participation is a democratic principle. How do you participate? The new way of participating is by teledemocracy, teleconferencing, for example. So we use technology to meet, but now the government use the law to block that kind of meeting. The other thing is the growing aspect of social media platforms. And that is something which the government tries and make efforts to block access to social media platforms. Now, with our laws, the social media are supposed to control and remove content that violate written laws. But the person who decides what is prohibited is somebody else. And what elements do they use to tell that this is prohibited is by going to the law. The law lays down a number of aspects which say that this is prohibited content. Of course, understandably, there is that famous thing about national security and maintaining peace and security and stability of the country. But who is the custodian of peace? It is the people. But it's the people who can keep the peace, and it's the same people who can destroy that pinnacle of democracy. So we also have the democracy. It's a question of data sharing, but also the government has come up with protection of personal data, and I know most of you own smartphones. You are sharing information. Actually, whether you have consented or not, there are things which actually you have to do. Otherwise, you cannot access your bank statements. So, but personal data protection has two aspects. There are those who are called data controllers and processors. You have to apply in order to collect the data, and you have to be licensed. But also, data subjects, the persons who are giving data, have their rights. So there has always been a problem when it comes to protection of data subjects. How is your data being protected. And when you are participating in the platforms, democratic platforms, how far are you sure that your information is secure? There is a new right which has developed, and I'm not sure if most of you know about it. It's the right to be forgotten. You know, when you share data on social media, it stays there permanently. It will only crop up when someone wants to make something bad against you. Like, for example, if you are running for Takaudiwan, they may remember that, one day you were charged with a criminal offense and actually you were jailed, so they'll bring it up. Or they will say, this guy used to fight a lot in bars and they were actually charged. So in Europe, according to their data protection law, you may apply to be forgotten. That is, all your information to be removed from data platforms. I don't know how many of you have applied for your data to be removed. You know, you have a lot of information you are sharing voluntarily on platforms. So when it comes to liberal democracy, that is also another challenge. That is, some of the information which is personal, you may not be interested to have it shared. But if it is on the platforms, how do you remove it? So those are the few areas where I thought I should remind you of thinking. And now we have to ask ourselves, is virtual democracy now possible? Are we, because now with meetings like this, you can have virtual meetings. Are we going to have a virtual democracy? That is, members of parliament sitting virtually instead of going to Dodoma for the obvious per diems and sitting allowance and sleeping allowances. Is that going to be a reality in the near future? Because that is where we're supposed to be headed, virtual democracy, because that is within teledemocracy. And I do not know any, maybe you will enlighten me, if there is any country which has achieved virtual democracy in terms of making people meet and discuss. Now, of course, there are challenges. Of course, one of the biggest challenges is the availability of constant supply of power in our societies, and internet access. You know, people now, of course, most people have access to internet, but if you want to have a functioning democracy, you must have access to reliable internet and also reliable power in order to perform. People have been making jokes when the standard gauge which school did they attend to know how to deal with those electric and why is it not happening nowadays? The monkeys are still there. So there was something more fishy. This something fishy can also happen when you are dealing with teledemocracy, because there are people who will not be interested to know that you are giving people to power. Finally, teledemocracy actually was envisaged in our Constitution. Our Constitution, of course, and some of you have experienced, that is, if the regulatory authorities think that certain information is not nice, they'll block access to social media. You have heard about X being blocked, Facebook, and our regulations talk about prohibited information in the Tanzanian cyberspace. Tanzania does not have a cyberspace of its own. This is a shared resource when you're talking about digital democracy. Now, how are we going to share the cyberspace? You cannot have it for Tanzania alone. So the best thing is to block access to information through those laws. Of course, people have been making a lot of noise, and I think they are right. That is an interference with the right of access to information and freedom of expression. So there are many areas where we can speak the whole day in the challenges, and I think because we are going to have a panel of able and spirited discussants, I think I should end here and take this opportunity to thank you again for giving me this opportunity. And with this keynote address, I think, Ukashu, I'm not supposed to say anything has been opened. Thank you.
Thank you so much, Mheshimiwa. I think Mheshimiwa Mheshimiwa nisikusumbue sana. I think the session inayofuata ni kupiga picha just shortly. So before hujakaa nilikuwa naomba Ukashu ungetuongoza kwenye hilo, watu ambao watahusika kwenye picha. Yeah. Yes, tunasimama. XCOM AYL. XCOM, yes. Naomba XCOM wote wa AYL. Jamani, hatujawatenga. Tunaanza tuna uongozi au tutakuja kwa makundi na tupate na sisi ukumbusho. Jamani, picha ni uhuru kwa hiyo ambaye angependezwa kupata kumbukumbu tusogee tu pale mbele. Sio kwamba yeah. Paka hapa yes, kwa upande huu yes. Kwa sisi tusimame kwa nyuma kwenye hiyo nani ya juu huko. tumemaliza. Kuna mtu tumemwacha? Panelist. Sasa yeah, thank you so much. So wakati wanaendelea kupanga, yes. So wakati wanaendelea kupanga, I think we have our timetable. The panel, the timetable inayofuata, it's a panel discussion. Sasa nilikuwa nimeangalia nyuso zetu. Of course, I wanted us kwenda kunywa chai kwanza alafu kurudi. Lakini sasa wanaendelea kupanga chai. Sasa ningependekeza tuendelee na hii panel discussion, which will be, haitochukua muda mrefu, then tuende tunywe chai, then to proceed. So we can all be active to that. Yeah, so the panel discussion, as we can see, it's a discussion on the role of young lawyers and the use of technology in the advancing democracy, navigating challenges and opportunities. And for our speakers, we have our first speaker, who is we have Dr. Belinda, we have Advocate Mugambila, and Mr. Joseph Gideon Lamek. But before the panel proceed to discuss the title, I would like to welcome Advocate Edwin Mugambila. Advocate Mugambila is a CEO of TRI and a former university lecturer, and a deep experience in the rule of law, anti-trafficking, and civic education. He brings the civil society and academic lens into legal tech. He will take us to as a startup for the panel discussion, with few slides for us to proceed. Then afterward, the panel will take over, and for you to contribute your thoughts. So.
Thank you so much. Good morning. Is it good morning or good afternoon? Good morning, everyone. Just as introduced, my name is Edwin Mugambira, a CEO for Tanzania Relief Initiatives. This is an NGO which deals with promoting human rights, democracy, and the rule of law. I am also a former lecturer at Tumaini University. I see some of my students in this house. If I ever taught you, wave your hands like this. Good. See my students here. Yeah, so I am asked to speak very briefly about the role of young lawyers and the use of technology in advancing democracy, navigating challenges and opportunities. Now, before we go to the key message of the presentation, let's first have a look on two important notes. We are told that young lawyers are not just the future of the legal profession. They are the essential architects of a resilient digital democracy in Tanzania. So we are the architects of a resilient digital democracy. How? We are going to see that in the preceding paragraphs. So by embracing technology and their unique role, they can ensure the law remains a tool for empowerment, not control. Therefore, we are going to look at the convergence between the law, technology, and democracy. These are our key terms. We'll also look at the unique position of young lawyers, why they are essential. Why are they essential? In doing that, we look briefly at the pillars of democracy, the challenges, and the call to action. And the call to action. Okay, I forgot and thought I was in class. I wanted to start with the definition of key terms, but because of the few minutes that I'm given, I will try to be as brief as possible. So here we are looking at democracy, technology, as well as young lawyers. Where do the young lawyers come? Democracy is built on rules, rights, and institutions. Technology is reshaping how these are accessed, exercised, and violated or abused. Young lawyers are at the intersection. They are digitally native, agile, and idealistic, equipped to interpret all the rules for new challenges. Now let's look at the young lawyers' roles in defending digital rights and civic space. Young lawyers' roles in defending digital rights and space. Why defending digital rights and space? It's because you are speaking about democracy. Democracy is all about freedom and the rights. Our previous speaker, his lordship, the retired but not tired Honorable Makaramba, gave us a very beautiful presentation of this. So our role as young lawyers is to use legal tools to protect. One of our laws is to use legal tools to protect online freedoms. How do we protect online freedoms? First is through strategic litigations. I see many potential strategic litigants in this house. So we can do strategic litigations to challenge unconstitutional laws. We have had Honorable Makaramba took us some pieces of statutes, like the EPOCA legislations and their regulations, the Cyber Crimes Act, the Access to Information Act, the Statistics Act, and the other many pieces of legislations. Some of them have ever been contested in court, but they are still applicable, and we are still complaining about them. If the community is complaining about them, that gives you an opportunity to take action. What action? One of such action is strategic litigation. Number two, what we can do for our community is digital rights advocacy, providing legal opinions on tech-related bills, like the ones I've mentioned and the others, engaging with the regulators, like TCRA, doing lobbying, TCRA. Now we have the Personal Data Protection Commission, is also a regulator, plus other bodies, and advocating for laws that protect privacy and free speech to avoid censorship. Now we are used to an adage. It has become very common. You are told that you have freedom of speech, but people are not sure about your freedom after your speech. So I think that's an opportunity for young lawyers. We can do something to remedy anything that deems to be a draconian piece of legislation. And number three is legal aid for targets. As young lawyers, we have an opportunity to represent journalists, to represent activists, and ordinary citizens who are targeted, arrested, or harassed for their online posts. Another one is use of tech tools. Advocating on the use of tech tools that are safe. Encrypted communication applications. I think you know them better. Most of you are engaged in online spaces. We used to Clubhouse. We have encrypted applications that you can advise people to use to make sure you are safe when you are doing communications, the likes of WhatsApp, Signal, and the others. Digital evidence preservation tools, online legal database, etc. So those are issues that can be done by young lawyers in defense and protection of the immediate communities. Now we have to note that technology is not an external force acting upon democracy. It is a tool. Its impact, whether it strengthens or weakens our democratic institutions, is determined by the people who build, regulate, and use it. We have our democracy, but whether we use it positively, we use tech positively, or adversely, whatever the outcome is determined by those who are vested with powers to man it. And we as young lawyers have the duty, the legal duty, to make interventions for safe use and enjoyment of these tools. Young lawyers equipped with both legal training and digital fluence are uniquely positioned to ensure this tool is used to build a more just, accessible, and resilient democracy. We can contribute towards that. Now let's look at few challenges. What are the challenges and what can a young lawyer do to bridge these challenges? We are talking of digital democracy. We are talking of digitalization. Yes, indeed, there is digitalization. Everything is now turning digital. But what are the challenges with turning everything digital? One of the challenges is digital divide. Digital divide. One of the problems we have is that tech-driven solutions assumes access to devices, high-speed internet, and digital literacy. This can exclude the elderly, the poor, and the rural communities. With this assumption, it works in favor of the Gen Z. The Gen Z and the millennials, you can assume this. How about your granny who is there in Ireje village, who was born in the early years before colonialism, who can barely access technology? How about your uncles who are in remote communities with no access to smartphones, no mobiles, no access to social media, no access to television and anything? How do you accommodate them? How do you accommodate them? So we have a risk of creating two-tiered system of justice and civic participation. So what can we do as young lawyers? This is an opportunity. Advocate for universal broadband as a public utility. That's very possible. Or design tech solutions that are accessible and offline compatible, ensuring analog options remain available. Hata bibi yako ambayo yuko kijijini anayetumia kiswaswadu, unaweza kutengeneza tool ambayo atapata taarifa muhimu hata kwa kutumia kiswaswadu. Au ka advocate for universal access to broadband utilities. That's very possible. As I finish, let's look at the ethical quandaries. Let's look at the ethical dilemmas and the professional duty, very briefly. Ethical dilemmas and professional duty, navigating the gray areas. One of such ethical dilemma is confidentiality and security. How do you secure client data on new platforms? What are the ethical duties in data breach? So as a lawyer, you must also be conversant with the data protection legislations. Have to be conversant with all the legislations related to data protection, and you must be in the position to exploit them, apply them in your favor and in favor of whoever you deal with. Another threat is unauthorized practice of law. Where does a helpful legal tech tool end and the unauthorized practice of law begin? Where? That's an ethical dilemma also in the application of these digital tools. Duty of technology competence. Model rules now often require lawyers to understand technology relevant to their practice. So as young lawyers, we should be in the position to do that. Technology offers a lot of opportunities, and we must understand them if we need to benefit from them. The young lawyers, in your continuous learning, push for clear ethical guidelines from stakeholders, TLS, TCRA, Personal Data Protection Commission, etc. Prioritize client security. In whatever you do, prioritize your client security. Now, what should be our call to action? What should we go with? We should go with the following. Become a tech literate, understanding the basics of AI, cybersecurity, and data analytics. That will offer you, that will broaden your horizon of practice and client base. Also, you need to specialize. Consider a focus in cyber law, election law, or privacy law. Work in collaboration with other stakeholders like NGOs, policymakers. We in NGOs, we work with law firms. You should not be cocooned in your law firm. You graduate your law school. Maybe you have a rich parent. He gives you a fancy office, fancy Chinese furnitures, fancy law books and everything, fancy AC and everything. You sit in the office, you relax. No, that's not the way. You should not operate in silos. You should be in the position to collaborate, partner, and engage. Engage with stakeholders from different walks, NGO sector, international organizations, media organizations. That way, you will explore opportunities and benefit from your profession. Push for legal and regulatory frameworks that ensure technology serves democracy, not undermines it. I think His Lordship Judge Makaramba spoke about this combination of innate digital fluence, professional agility, a fresh innovative mindset, and a profound personal stake in the outcome that makes young lawyers the essential catalysts for progress. Young lawyers are the bridge between the enduring principles of the law and the dynamic force of technology. Thank you for listening to me.
More round of applause, please. I don't want to, I'm not sure if you can sit because I still need you. Yes, for the panel discussion. And this is our first panel discussion, who will be now keeping on the discussion and further evolve on those ideas. The other speaker on this panel, we have Dr. Belinda Chemchumba. Dr. Chemchumba is a lecturer and head of department at public law at the University of Dar es Salaam School of Law, and an expert in human rights and migration, and currently a postgraduate fellow at the University of Witwatersrand. I think you will pronounce that later. You will teach me how to pronounce. Yes, thank you. Our final speaker is Mr. Joseph Gideon. Karibu. Joseph Gideon is the vice chairperson of the TLS Association of Young Lawyers and a partner at the Law Network Attorneys. He actively engages in legal research and policy reform. So allow me to welcome them on board and for just a round of applause for them before they proceed. A round of applause, please. Yeah, so thank you so much, Mr. Mugambila, and for the nice and a vibrant discussion. But I think it's a question that I will ask you, and I'll ask the panel, but also later I will ask our Honorable Dr. Makaramba, because the key issue here is we can have all these tools. We can have the ways of strategic and digitalize and all those kind of things. But I think the most key thing here, I think we also the audience will agree with me, is how now to generate that kind of mentality now as a young lawyer to be able now to speak. We have seen from the discussion of previously of our keynote speaker that we are supposed to be allowed to speak. That I mean, you have to be permitted to speak. That right of speak, be able to speak without any repercussion, whether online, whether physically. I think that's the key thing, of course, for also our forthcoming speakers will also pose that question. As a young lawyer, we know that we have a long future and all that. So most of them, because I'll give an example. I was talking to few of the young lawyers before, fellow young lawyers actually, that there is an event today, let's go. The first thing they asked me, what the theme of the event? And I told them it's an issue of democracy and election. So for them, they said, nope, I can't talk. I won't be able to, I fear to come and speak because it's election. So that is one among many. You see, you agree with me. So I think our discussion also can go to that. How now are we going to eradicate or to remove this fear from young lawyers so that they can be able to utilize the tools and also to navigate the online, the democracy. So to start with, Dr. Mugambira, correct me if I'm wrong. Can I call you Doctor or Mr. Mugambira? Mr. Mugambira, thank you. So, Mr. Edwin, as a young lawyer with experience in both human rights and litigation and NGO leadership, how can young lawyer now, who are listening to us, right now, balance the two between the advocacy and digital activism while staying within the ethical and legal boundaries, especially this time around of election? How can they balance that?
Thank you so much. That's a very good question, asked at the right time. It's indeed a challenge to balance advocacy with the strict confines of ethical obligations. It's a defining challenge for the modern human rights lawyers, particularly during the high stakes environment of an election like this. During the high stakes environment like the one we have now, it's really a defining challenge. Now, young lawyers ought to anchor themselves in 3 core principles. For us to be able to thrive in this, we have to be able to anchor ourselves on 3 key principles. Number one, before you post, now I'm speaking of technology, before you post any tweet, let's say, or share any information related to the election, or legal processes, or opponents, you must verify it with the same rigor you would apply to evidence submitted before a judge. Now the issue is verification. I'll tell you why, and after verification, what will you do? So spreading unverified claims, even with the best intentions, undermines the very justice system we are sworn to uphold. Therefore, the first thing that will make you safe in moments like this is to make sure that you are confident with what you are posting, with what you are speaking, with what you are saying. Should bad thing come up to you or upon you, then you have the legs to stand and defend yourself. Even other people have the legs and the confidence to defend you. With the other people, I am referring to TLS and the other stakeholders. That's one. Number two, clearly separate your personal and professional identities. This is very key, though difficult. The dichotomy between your personal and professional identities have to be clearly demarcated. It is increasingly difficult, but it is essential. Now, what would be a useful strategy? It would be a useful strategy to have a professional account dedicated for your legal analysis. When advancing your arguments, legal arguments, citing legal provisions, avoid inflammatory languages. This is very important. When you are advancing your opinions, legal opinions, you are serving your clients, you are giving your comments, you are giving an opinions on a matter of public concern. Try to avoid inflammatory languages. That will make you more safe. And if you have your personal account, it should still be governed by a sense of professional responsibility. Even if you have a personal account, it should still be governed by a sense of professional responsibility. In other words, never say something online you would never say in courtroom. Never say something online that you would never say in courtroom. Yeah, we might have a bad example. Within TLS, we might have one person who might say something, might say everything, is a self-regulated person. But these kinds of persons should not be an inspiration, but rather be inspired by people who are professionally and ethically governed. Number 3, that was principle number 2. Number 3, see digital tools as a supplement, not a substitute for traditional advocacy. You know, in the age of democratization, digitalization, and globalization, everybody posts everything in the digital platforms. Whether it's true now, this brings the concerns of dis and misinformations and everything. So it should be a supplement, not a substitute. Use social media to mobilize, to support, disseminate verified information and raise awareness. But then channel your energy into actionable on-ground legal work, e.g., filing strategic suits, documenting human rights abuses with the proper chain of custody for digital evidence, advising civil society groups on their rights, and advocating for policy changes through formal channels. The goal is to use digital platforms to bring people to the court steps, not to replace the courthouse itself. So therefore, fellow young lawyers, if I were to comment on the question advanced by the council, those would be my humble comments on the subject. Thank you so much.
Thank you so much. And I think you touch base most of the things that we will be hearing from the other panel who will be covering the counter mis and disinformation. So I will encourage you all after breakfast, then we come back, because we'll have a session specific from Maxence Melo, who will be the Executive Director of Jamii Forum, who will take us through mis and disinformation. So to proceed with, of course, I agree with you, which is very, very right. But now it raises another question that, okay, I'm a young lawyer. I want to be part and parcel of digital democracy and be part and parcel of seeing that democracy is upheld. I want to file a case maybe, but I'm a young lawyer. We know the common problem of us young lawyers, fee. I mean, how can I now counter that kind of funding or finance to go through it? But before we go through that, I think now we can relate the base. The base here is academics, I mean, from the universities. And now we have Dr. Chimchumba. Doctor, what role do you think academics and researchers play in supporting young lawyers now to leverage this kind of technology for democracy? As academic and research, what do you think you play a role in this kind of cycle?
Let me first take this opportunity to congratulate Advocate Edwin Mugambira. He's my classmate. We were classmates, and we graduated, and we were both retained as best students at Tumaini University as tutorial assistant. Then later on, we went different paths. I'm now lecturing at University of Dar es Salaam School of Law, where I'm also the head of department, and he's in the issues of NGO. So we have been working together with Muga, and I'm sure we have most of our students here. And it's a privilege when you meet after a very long time, and you're all coming in to talk about one common agenda, which is digital democracy. So as academicians, we have a major role to play. First, I want to say that issues of technology, it is unquepecable. You cannot quepa issues of technology and issues of artificial intelligence. Now it is coming in very strong. For example, it is now very difficult to establish whether this student has written his or her own dissertation or assignment. Even replying an email, students are now using AI. Yani you send a message and that student copies and takes it to AI. Please reply this. Nowadays, it is a challenge. As lecturers, we set questions using AI. Students get their answers through AI, and we also mark through artificial intelligence. So issues of democracy is something that we cannot run away from it. It is there to stay, and what I'm trying to do, what we're trying to do as an institution is to ensure ethical use of this technology in all grounds, in terms of education, in terms of ensuring that we can foster democracy. And I'm coming back to your question. You're saying, what can we do? Recently, all higher learning institutions, we are doing curriculum review. We are reviewing our curriculums. We have something called the HIT project, where all universities are reviewing their curriculum in order to incorporate issues of technological advancement into the curriculum. We are coming in, we know the traditional laws, for example, constitutional law, criminal law, these are traditional laws, but we are now bringing on board new modern law. For example, we have internet law, we have issues of artificial intelligence, we are bringing in artificial intelligence law. How do we incorporate? We have issues of copyright. When you talk now about copyright, it can be overtaken by events because of AI. When you talk about issues of privacy, it has become a challenge in terms of artificial intelligence. You don't know who you are dealing with. It has become a challenge. So now, as higher learning institution, in order to ensure issues of digital democracy, we are amending or we are reviewing our curriculum to be in line with this technological advancement. Thank you.
Thank you so much. Yeah, a round of applause, please. Thank you so much, Doctor. I think it's, I'm not sure if I wanted to say that we are there or we are late to review the curriculum, because I wish I could have been there back in the university where curriculum have been now reviewed and copying the current situation. But congratulations for that. So moving forward. I wanted to get an insight now from the young lawyer who is actively in real life examples, Mr. Gideon, as a vice chair of TLS Association of Young Lawyers, what are some of the real life concerns that you think as peers express about engaging in platforms, social media platforms, be it X, be it Instagram or the like, during especially this kind period of election? What are those real life example concerns that we think as peers we have, and maybe you can touch a bit on how now to mitigate them before?
Okay, I'm firstly very glad to be here with different distinctly colleagues for the purpose of answering your questions. There are several concerns that most of young lawyers are raising when it comes to their engagements on social media platforms such as X, formerly Twitter, Instagram, WhatsApp, and so on. And this normally happens where they're expressing their views, particularly to issues pertaining with rule of law and democracy. So I've been receiving several complaints from young lawyers, and the most complaint, I just received it this Monday. So, being brief is that among the problems that most of young lawyers, including myself, that we are encountering when it comes to our online expressions of our opinions is censorship. So, there are these people called maafisa wa doria mtandaoni. You might post something, but you end up being intimidated, like you should shut it down because it is not praising a certain class of people. So censorship is the main problem that most of us are encountering, also from the communication regulator. The officers from the authority that deals with communications, normally inboxes some of our members claiming that maybe what they have just posted is contrary to law. Even if you review your posts, you might find it not being offensive or contrary to law, but they're there simply to protect what they think is more beneficial to them. So the most challenge that most of young lawyers are encountering when it comes to online expression is censorship. Apart from censorship, most of young lawyers are afraid of being misunderstood or misquoted. You might express something genuinely and without any negative influence, but some people might take it in a negative way. So some of young lawyers are afraid to post because they feel like once I post something, maybe it will be misinterpreted, so that to be seen that I am misleading the community. So it's one among the fears that most of young lawyers are afraid of when it comes to engagement online. The other thing is most of young lawyers are afraid of marking a demarcation between their personal opinions and their professional responsibility. For example, one might be interested to post something or to express his view in an ongoing online debate, but sometimes he thinks of his client. Maybe in case I give an opinion on this topic, maybe my client will not be fascinated with the opinion that I'm giving on the subject matter. So this will make him maybe not to proceed because of the fear of losing the client. So professional responsibility and personal opinion sometimes is a problem that encounters most of young lawyers from expressing their online views regarding to issues of democracy and technology. Lastly, there is this issue of digital harassment and trolling. Currently in Tanzania, especially on Twitter, currently X, most of people, especially these public servants that are holding higher positions, normally higher people, so that we encounter whatever you give us your view with regards to their way of doing their job. So you might write a very good very good opinion with regards to their performance, but there are these people who will just come and troll you so that your point to be seen as being pointless, despite of having a very clear and good point. So these are the problems that are the real concerns that most of young lawyers encounter during their online expression of views and integration.
Thank you so much, Gideon. You raise a very critical question that which pose another question on now, how can I, as a young lawyer now, now differentiate or distinguish now between legal commentary and they say digital populism, like influence anything that is not professional. So what do you think we can distinguish that? I mean, when someone is, I will give an example. I mean, and I will particularly want this question to be answered by Mr. Mugambira. I'll give an example. I might see something that is circulating online, maybe a political person have done, like maybe RC or someone else of that regard. And as a legal profession, I feel like I have an obligation to advise the public that this is out of bias. I mean, the law which mandated you to do this, you're going outside that scope. I feel mandated to do that. But now how can I differentiate between that legal commentary which I'll post online with being regarded as populism or want someone to influence something else to that regard? How can I differentiate that? Yeah, you can start, but also we can.
Okay.
Yeah.
Responsible commentary and all legal commentary are normally grounded in law, fact, and ethics. If you're giving your opinions, but you ground your opinions with laws, ethics, and principle and jurisprudence, we will normally take you not chasing crowd, because if you ground yourself, if you ground what you're saying with laws, ethics, then you're making points. Unlike populism, treating populism, say, for example, is normally encouraged with emotional appeals, oversimplification, sensationalism, and the like. So once you ground yourself in laws, ethics to back up your expressions, that should be taken to be responsible commentary. So young lawyers should always ensure tweeting all, expressing on voters' rights, say, democracy, instead of choosing political sides, which will always take you to be seen as seeking or chasing crowd for the purpose of being popular.
Round of applause for that. For the panels in general. Mr. Mugambira, can you add on that?
Yeah, I subscribe to what my colleague has just spoken. I will add very few remarks. In the first place, our young lawyers should not feel frightened to give opinions or commentaries on any social community or legal matter. That's the constitutional right, and Article 18 of our Constitution of the United Republic of Tanzania. However, as lawyers, just as my friend, I will allude to what my learned friend has just spoken here. There are matters of law where we as lawyers may be professionally obliged to comment. Especially when I was coming here, I'll give a small example. When I was coming here, going through social media to see what is transpiring today, I met one post with the demand notes from Jubilee Insurance. They sent a demand notes to one of the socialites for having defamed that insurance company. Now I read the demand notes. Then I went to see what this lady posted regarding those allegations. I was surprised. Now I opened the comments part. Opening the comments, some of the people who commented there were lawyers, some of whom are famous lawyers that I know. So you may meet a situation like that, where you feel that you need to educate the community on a particular matter. I was very moved because it was an issue concerning insurance. And I have taught insurance law at university. I want to know what is happening, what is traversing here. So I learned about something. Now, as young lawyers, we should understand that also our regulations mandates us to give legal commentaries in matters that has to do with the law. However, it has restrictions. For instance, if a matter is in court, like we have some most prominent cases in court now going on, there are restrictions on commenting on issues that are on court. Maybe after the case has been determined, you may give a comment on just determine the case law, and determine the court case, how it was decided, the legal principles surrounding the case, and everything. So the bottom line here is we have the right we have rights as ordinary citizens, and we have a duty as legal professionals. So we should know what time to exercise our rights and what time to discharge the duty to the public as the legal professionals. Remember, you have a duty to the public, you have a duty to your client, you have a duty to the court, you have the duty to the fraternity. Thank you.
Thank you so much, Mr. Mga. Now, picking up from there, now turning back that reality to academic institutions, because now if you want someone to practice being free to speak and the use of these tools to promote democracy, it has to come from the universities and the high schools from there. Now, Dr. Belinda, do you think now, because we came from the situation where someone who is on top of you doesn't want to be told the truth. I think it's even the reality right now. So as an academic institution, do you think now the universities are ready to have those kind of students who are vibrant, who can express themselves using these kind of tools to express themselves? Do you think you are ready to that?
Thank you very much for that question. It's an interesting question. By the way, if you look at, for example, I'm using University of Dar es Salaam as a case study. Things have really changed. We have young lawyers, we have young doctors and professors from the School of Law. We have Dr. Kaitu, who is with us. We have a lot of lecturers who are below 38 years. I got my PhD when I was hardly 30 years. So you can imagine how we are very ready to embrace changing of technology. There are situations where a student is very smart, that when you are marking his script, you have to use it as a marking guide at the end of the day. So we have very smart students, and what we do, we mentor them. We have reached in a situation whereby even young kids are now using technology, and they know so much more than some of us. There are some of us here, we only know ChatGTP. But there are Gen Zs who know more than 110 ways that you can use artificial intelligence. We have Gamma AI. We have a lot of deep fakes. So nowadays, we also learn from our students. It is not it is a two-way traffic. We also get some of the information from our students. For example, I'm teaching at we have masters. I'm going to a class whereby all my students, I have a judge in my class, I have state attorneys, I have, very prominent people, and you are there for the first time. In fact, the first time I went to teach masters when I started working at University of Dar es Salaam, it was very difficult. What did you tell them? I'm teaching ADR, and you're asking, what is ADR? You cannot ask a judge what is ADR. These are things they're doing, So we have reached a time now whereby we are even changing the way we teach. We no longer lecture in class. We just give them case studies and we tell them, let's have a discussion, because they might know more than you know. So issues of technology has really leveraged the way that we get information nowadays. So we are embracing and we are ready to go forward. Thank you.
Thank you so much. I mean, I like the fact that you're mentioning that we have now not only young lawyers, we also have young lecturers for most of the university, which is a good thing actually. So thank you for pointing out that. So yeah, before moving forward, maybe we can have a few questions from the audience. If you have any comments or any question, feel free to ask particular panelists or anything, feel free. The room is yours now. You can raise a hand and we can bring you the mic if there is any question so far.
Thank you for the opportunity. As they were presenting, I was highly disturbed in my mind on the aspect that we're expected as young lawyers of whom we should bring changes through the digital platforms for democracy. And we are expected to be defenders. But it has disturbed me for a while that since we've been schooling before becoming lawyers, that has never been the subject of our own. Now, having lecturers and having advocates of whom they have opportunity to frame the laws, and I was very careful to listen to Advocate Edwin saying that law should not be a tool for power, if I'm not mistaken, but for enabling or empowering. That was the term. Now I'm very eager to know from the presenters, if at all, there has been a work done to ensure that the law is truly prepared or enacted to empower the very young generation, so that at the end of the time, we cannot use a lot of effort to invite young lawyers to participate in digital democracy as we now do. You have given an example of a young lawyer who was not interested to come here and to learn so that he can help others. So if my question has been delivered into their brain, or if yet, I can repeat in a very simple way.
I think they captured it correctly. So who will want to start answering that? Because it's any panelist, huh? Yes. So.
I can go briefly. Thank you for the question. And we really, issues, when we talk about law, in Tanzania, we have something called legal pluralism. We have a lot of laws in Tanzania. From customary, we have a lot of laws. And that is one of the challenges. I'm writing a paper now on issues of post-Rebecca Gyumi case. What has been done? And is it possible to amend the law? And one of the issues that I've been looking at, when I look at the trends, legal pluralism is a problem in most of the East African countries and even most of the sub-Saharan countries. When it comes to the challenges, we have a lot of laws. So it becomes a challenge to progressively ensure that the law is now used to protect. Because there are some of the laws, for example, I was talking to Professor yesterday, Professor Majamba, and I was saying that, why is it a problem that we have not amended the law? And he was saying some of these laws are there in the religious books. For example, when you go to Quran, there are some of the things there that you cannot say that the court cannot declare the Quran to be unconstitutional. How can you do that? You know, for example, we are talking about issues of illegitimate children. It is there. in the holy books. You cannot go to court and challenge the holy books. So when you're saying that the issue of religious legal pluralism, it has become a very big challenge in terms of progressing and defending human rights. But there's light at the end of the channel. Let us keep pushing. Thank you.
I think she captured it correctly, or if there is any addition from the panel. Yeah. Do we have other questions from the audience? Yeah. Let us be brief, so because I know the faces are hungry, or am I mistaken? So let us be brief, direct to the question, and we can proceed. Yeah, Karibu.
Thank you. I'll be very brief, but before I give my question, I'd like to give a short statement. I believe that what is happening online is precisely dependent on what is happening offline. To mean whether from practical aspects of infrastructure, access to healthy, or ideational issues like civil participation. What can lawyers do in a society which is deeply ingrained in fear, especially young lawyers? Because we see our society is deeply getting in what I call a police state, excessive use of force by the police and, of course, members of the intelligence community. Please don't quote me, but as lawyers, we know this reality. However, in matters that you want to address something online, whether it is a political reaction, political view, or any legal matter, there is a lot of societal reaction to that. If you give it professionally, you are being insulted because people are just reacting. They don't see the context of the point. If you say your personal views as a citizen, ad hominem, more insults are also coming. So in a way that you find yourself not having the confidence to act as a lawyer. I have a short experience of being in a few countries. For example, back in August, I was in India, then I went to Geneva. Their lawyers are extremely very free, regardless of what reports or views they are giving. Now, my question, to be brief, is in Tanzania, what can lawyers do in a society which there's a lot of threats to lawyers themselves, but even the society itself has a lot of anger against anyone?
Thank you. And I think you remember that was the gist of the question that I posed earlier today. How can we do, what can we do now to remove this fear mentality to most of the young lawyers so that they can be free enough to express themselves? But from my point, before the panel going, I think it's two-way traffic. There are some of the things that can be done to the young lawyers, but also there are some of the things that needs to be done on the other side who felt threatened by those kind of frauds. But let's hear from the panelists. What do you think can be done to that regard from the question from the audience?
Okay, I would like to say some few things on what should be done by young lawyers during online exception so that we encounter fear. The first thing is we need to be confident, and confidence is brought by being knowledgeable with what you are likely to express. So once you know the laws and the procedures, then you'll be confident in what you are going to express. And if you stick on the law and procedure, I'm quite sure that you will just express something which is not offensive. Another thing is that as young lawyers, we should always stick on code of ethics. We have the advocates, professional conduct and ethics regulation, government notice number 118 of 2018. So if we stick on code of ethics and ask ourselves before posting anything that whether the post that you are likely to post aligns with our code of ethics, then you'll have no fear because you'll be posting something which is correct, genuine, and not misleading. So these are some of things that can encourage young lawyers to encounter fear without being influenced by issues like political sides.
Thank you. You have anything to add on that, briefly?
Yeah, thank you so much. I will add on what my colleague has just said. I think we only need resilience. We need to be resilient as young lawyers. In our infant democracies, which is the case in most of the African countries, these kind of turmoils are a common practice, especially in times, in critical times, such as times of elections, times of political pressures, etc. So in becoming resilient, you need to make sure before you say, you comment on something or you do something, you have to ask yourself a number of questions. Number one, is what you are speaking, you are commenting about, you are doing, is it right? Is it legally supported? Have you followed all the procedures? If all the answers are in affirmative, then do it, regardless of whom you will disappoint. You will likely disappoint some groups of people, and maybe there might be consequences. But when consequences come, and you are sure that what you have spoken or what you have done, you have breached no end law, then you are safe, and you can successfully defend yourself. Number two, of course, as lawyers, we come across scenarios where we need to defend other people. It's not necessarily a scenario that concerns you. There are situations where some community folks are harassed, they are arbitrarily arrested, detained without trial. Then as a young lawyer, what will you do? Maybe he or she may be your relative, your friend, or as a concerned citizen, you may need to take action. So I think some of those actions you have spoken about, issues of strategic litigation, filing habeas corpus applications in courts, speaking out loudly, calling for solidarity, using online platforms, etc., until justice is done. The ends of justice must be met no matter what the consequences will be. And justice is never given on a silver plate. Thank you.
Thank you so much. Doctor, do you have anything to add on that? So if we finalize on that, starting from Doctor, in one sentence, what is your key takeaway from this discussion so that others, us young lawyers can take it?
Okay, my key takeaway is that when you talk about digital democracy, it should be treated, every country has its own special issues. We cannot be comparing countries. And we should use digital in an Afrocentric manner. We should come up with our own principles that we want it to guide us as a country. And we should use the law in a progressive manner to ensure that issues of digital democracy is met in Tanzania.
Thank you. And Mr. Mkambia, just briefly, key takeaway.
Digital literacy is paramount. In the digital world that we are, we as lawyers, we have to understand that digital literacy is an inevitable matter. So we should strive as much as possible to be literate in the digital platforms as much as we can, including understanding the laws and the regulations governing this digital world. Thank you.
Thank you so much. Mr. Joseph.
Okay. My take on digital democracy is that we as young lawyers, we should be responsible. Like, we should not be engaging ourselves online for the purpose of chasing crowds. We should always remember reputation is long-term. A single reckless tweet might hinder your practice, but being responsible adds trust and credibility on you. So we should all be responsible when it comes to digital democracy.
Thank you so much. Yeah, thank you so much, Dr. Belinda. Thank you, Mr. Mugambira and Mr. Joseph, for a wonderful and vibrant discussion. I think you will agree with me, and I will sit on your round of applause if you really, really enjoy to that. Thank you so much, the panel. I think we can have a picture, then we can proceed with other schedule. Pictures for the panel, yeah. So our next schedule is tea break, which will have half an hour. And I will encourage you to come back because our next speakers, we will explore more on what we have been discussing so far. Like I mentioned earlier, we will be having, first we'll be having Honorable Robert Vincent Makaramba to speak on safeguarding civil liberties as it shows on the timetable. But also we'll have an Executive Director of Jamii Africa, Maxis Melo, who will be speaking on mis and disinformation. Then later on we'll be having a civic tech innovation from Advocate Fatma Haruna Songoro. So for this time, I will welcome you all for the breakfast, which is outside the door on your right. After that, let us be punctual that we can come back and proceed with other formalities. Karibuni. aniambie tu yeye amepoteza shilingi ngapi, alafu tumwambie ndio hiyo au sio hiyo, alafu tutampatia. Yeah, so without kupoteza muda, I think we all know I think we have this timetable, na ratiba inayofuata ni ya Mheshimiwa Judge Robert Vincent Makaramba, ambaye atatupeleka through the topic on safeguarding civil liberties in elections, the role of legal frameworks and digital advocacy in Tanzania. So tuwe attentive, tuandae maswali kama yapo, na wale online pia maswali mnaweza mkaandika kwenye message, then tutayasoma. Tusameni sana tulishindwa kuyasoma ile ya kwanza, but this time around if there is anything pia online, maswali and all that, just feel free to write them and we will read eventually. Mheshimiwa, karibu.
Nikizungumza hapa wa online watanipata. Ya, habari za mchana. Kwanza ongereni kwa kuwepo mpaka saa hizi, kwa kweli WAKILI imebadilika. Maana niliwahi kuwepo hapa siku moja tukajikuta niko mimi na viongozi. Kila mmoja anasema bai, wanasema wana shughuli muhimu. Alafu kienda hapo shughuli muhimu ni ipi sasa? Kumbe ni Ijumaa. Sasa I've been asked to make a presentation on election law and civil liberties, to discuss the role of legal frameworks. Tangu asubuhi nilikuwa nazungumza Kiingereza, alafu sisi wenyewe humo si unajua tena. Watu tutazungumza Kiswahili tutachanganya humo tu. Wanasema kazi kubwa ya wakili au mwanasheria ni kuweza kueleza jambo gumu kwa lugha nyepesi kiasi ambacho mama yako ataelewa. Unajua kina mama huwa ni wagumu kuelewa mambo. Sisemi kwamba ni wajinga, sababu huwa wanatafakari kwanza kabla ya kupeleka hiyo hoja kwa baba, si ndio? Kwa namna ndio usemi. Na nafikiri ndio maana wanaishi muda mrefu kuliko wanaume. Ukipiga huku Mama Nyerere bado yupo. Mama Karume bado yupo. Sisi wanaume hayati. Sasa mmeiona hiyo picha hapo? Hiyo picha ni ya blindfolded Lady of Justice, amebeba ballot box. The message is, baada ya kura wanahamishia ugomvi mahakamani ambako tulikuwa hatuhusiki. Alafu wanawatafuta mawakili wa kuwatetea ambao hawana mpango wa kugombea cheo chochote. Kwa hiyo mna role hiyo kubwa. Lakini sasa kwa Tanzania hatuna mambo ya kidijitali sana kwenye uchaguzi wetu. Sasa tutaangalia hii concept ya uhuru wa kiraia na haki za binadamu zinahusiana vipi, na jinsi gani miundo ya kisheria inaweza ikalinda huo uhuru ambao tunao. Sasa kwa kawaida tunaposema sheria inalinda uhuru, hapa tunalenga sheria ilinde uhuru tuliopewa nao kwa ajili ya kutekeleza lengo la utawala wa sheria, ambayo sasa human rights na utawala wa sheria, yani haki za binadamu na utawala wa sheria, ndio kitanda cha demokrasia. Kidemokrasia inalala hapo. Kwa sababu discussion yetu tutajiangazia zaidi kwenye sheria mama inasema nini kuhusu hizo civil liberties na vitu kama hivi. Sasa kuna huyu judge, nadhani mlikuwa mmemsoma wale ambao mnapenda kusoma anyway, anaitwa Leonard Hand. Mmeshawahi kusikiaga hilo neno Mwaka 74 alisema, nitakoti kwa Kiingereza, it's very important. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. While it lies there, yani kwenye mioyo ya wanaume na wanamama, it needs no constitution, no law, no court to save. The problem we have in many African countries, liberty hailali kwenye mioyo yetu. Na ndio maana tunahitaji sheria kulinda. Sababu hata viongozi wetu wanaona ni rahisi zaidi kuvamia mioyo yetu na kutunyanyasa, na ndio maana tunahitaji sheria za kuzuia hawa viongozi. Ndio maana tunazungumza habari ya safeguards against liberties. Kila mtu anazaliwa na uhuru, lakini baadaye inahitaji ilindwe na sheria. Na tunaposema civil liberties ni neno ambalo lilikuwa linatumika sana tunazungumza habari ya digital. Hizi ndio changamoto hizi. Inaamwaga tu kwamba sitaki kusogea, kwa hiyo inabidi turudi manual. Yeah. Kwa hiyo sasa, what are civil liberties? Hizi uhuru ubinafsi huu ni uhuru gani? Maana tumeshazoea kusikia human rights. Yaani sasa tunazungumza habari ya civil liberties. Hizi ni fundamental personal freedoms. Fundamental personal freedoms. Ni ya kwako tu. Hauwezi kushirikiana na mtu mwingine, ambaye na protect mtu kutoka arbitrary government actions, ili kuweza kuhakikisha haunyimwi hizo haki za msingi na uhuru wako binafsi bila kufuata taratibu za kisheria. Kwa ina maana pamoja na kwamba wewe una personal freedom zako, they are not absolute. Sina mwenzio naye anazo. Kwa lakini lazima kufuatikane utaratibu wa kisheria. Sasa hizi personal liberties, they include freedom of speech, stroke expression, stroke opinion, na the press. Na ndio zinajikita sana hapo. Uhitaji kuwa na mtu mwingine ili uweze kutekeleza haki yako ya kufikiri. Are you following? Do you need someone to cooperate with in order for you to speak? Si unasema kilichoko kichwani mwako. Sasa kwa sheria zetu sasa hivi, kilichoko kichwani kwako hakikisha kikija kutoka kisiumize serikali. Maana nao utaumizwa. Hiyo ndio tatizo. Kwa sababu gani? The freedom is not absolute. It has limitations. While no right is absolute, it has limitation. Tutakuja kuona huko mwishowe limitation hizo zitakuwa justified vipi. Lakini the most important thing ni kwamba hizi haki sasa, kwa sababu ya serikali kuwa zinatishia sana hizi haki, zinabidi ziwe guaranteed at the international level. Ziko kwenye mikataba ya kimataifa, lakini at the national level tumeziingiza kwenye katiba yetu, kwenye Bill of Rights and Duties. Katiba yetu ina Bill of Rights and Duties, na sio haki zote zinazotambuliwa chini ya Umoja wa Mataifa zimeingizwa kwenye Bill of Rights and Duties yetu. Sasa manake ni nini? When a constitution has a Bill of Rights, it limits government power and uphold individual dignity. Sababu any constitution kazi yake ni kulimit government power. Kwa sababu power nayo huwa ina corrupt, and absolute power corrupts absolute. Ukitaka mfano mzuri, uende mbali sana, unaenda Uganda. Change the constitution, useme I will be the president until death do me apart na nyinyi. Ni mahali gani ambapo huwa mnakulaga hicho kiapo? Huwa umeolewa? Hujaolewa, huwezi kujua hicho kiapo. Walioolewa ndio wanajua, eti mpaka kifo kitutenganishe. Alafu kwa nini mnachukua visu mnaanza kuua waume zenu? Mnatenganishana? Alafu wadada sasa hivi mna tabia mbaya. Mnavizia tumelala, mnaanza kutunyofolea viungo fulani fulani. Sasa kuna mdada mmoja akasema mimi nikitaka kwenda kulala na hakisha visu vyote nimefungia kwenye safe. Maka tuaminiane. Akimsikia anamshika, akimsikia mwenye, sio wanakumbatiana kwa mapenzi, ni security. Asije akaamka mtu akawahi kuua. And you surprised kwa nini sasa hivi vifo vingi vinatokea kwenye families? Sasa sisi we are talking about protection of personal liberty, alafu tunaondoleana sisi wenyewe kwa wenyewe. Freedom of life. Sorry. Kwa hiyo constitutional provisions na sheria zina define hivi vifungu. Lakini baadaye kama vikiwa violated, we go to court. Haifore. Mahakama ndio mamlaka ya mwisho ya kudetermine haki za mtu. Lakini tunajiuliza, ni mahakama hizi za Tanzania sasa hivi ambapo ukienda hauna uhakika kama there will be a determination of finally of your matter. Ukuta na majaji nao wanakushangaa wewe. I'm very impressed. Mwaka huu ndio imetoka ile kesi ya Bradea. Alafu juzi wametoa ingine kumwambia kwamba kesi ya kwanza ambayo imetest whether the Independent National Electoral Commission is really independent. Lakini wamemwambia very strange. Msajili wa vyama kampelekea amri mwenyekiti wa tume kwamba mzuie mtu fulani asirudishe fomu na mwenyekiti akakubali. Alafu sasa the most interesting part, msajili wa vyama ni jaji mstaafu wa mahakama kuu. Mwenyekiti wa tume ya haki za binadamu ni sitting judge wa court of appeals. Jaji wa mahakama kuu anamwamrisha jaji wa court of appeals. Sema hii inaweza katokea tu Tanzania, sio mahali pengine. Sasa wameenda mahakamani, wakashinda. Attorney General kaibuka huko na kesi mpya. Na Mpina naye ameenda amemshtaki sasa Attorney General na INEC. Yaani huu mchezo sijui utaisha lini. Kampeni zinaendelea. Wao wako mahakamani na kampeni zao. Mpina amesema hata ikibaki siku moja mimi nitashinda kwa 70%. Ile confidence ile ni ya ziada. Kwa hiyo mnaweza mkaona jinsi gani ambavyo personal liberty ya mtu inaweza ikuwa affected kwa sababu haki ya wewe kujiexpress. Sasa what are the key characteristics za hii civil liberties? Ya kwanza ni protection from government. Si tulisema sababu government ina interfere. Ndio maana we need to protect against the government. Na ndugu zangu, haki haipatikani mezani. Inapatikana kwenye mapambano. Kwa hiyo nilikuwa nasikia young lawyers hapa wazungumza habari, mnaenda kufanya majadiliano na mahakama na serikali wape haki. You fight. Na ndio maana nasema in order for you to be able to fight, you must have courage. Mawakili wanaoendesha kesi za human rights mara nyingi huwa hawalali kwenye address zao. Sio, mnanielewa? wanahama, maki wanawindwa. Haifuri. Wanajua if you kill the advocate, you kill the case. Kwa sababu hawezi kumuua jaji. It is easier to kill an advocate. Kwa hiyo those are one of the problems ambayo tunazipata kwenye hizi nchi zetu. Sio Tanzania tu, everywhere. Haifuri. Wasipoweza kukuua physically, kuna sheria inaita money laundering, anti-terrorism, tupo hapo. Unamkamata wakili, unamwambia ameleta maneno ya uchochezi, kwa sababu atapata baili, unaongeza na money laundering. Alafu nasema hamna baili. Kwa hiyo ndio maana wanaogopa ile fear of the unknown. Hawajui kama kitatokea nini kama nikienda kushika hizo kesi. Lakini kama nilivyowaambia, haki haipatikani mezani. It is through fighting. Individual rights wanasema ni inherent and fundamental ambazo mtu unakuwa nazo. Wewe kwani kuna mtu alikufundisha namna ya kusema? Si ulijikuta tu unasema ovyo mpaka leo unasema. Hasa hapo na mtu mwingine anakuambia usiseme. You have no right to speak. You have no right to speak. Haifuri. Sasa lakini vile vile ina engage na due process. Due process maana yake nini? Endapo haki imeingiliwa na serikali au taasisi zake, lazima uende mahakamani na kuwe na fair and established legal procedures, ili muweze kuwa na fair trial. Na hizi procedure ndizo ugomvi uliopo kwa Tanzania vile vile. Are our procedures fair? Ukitaka kupursue human, wanatoa kwa mkono huu, wanautoa kwa mkono ule. Katiba yetu, na utakuja kuona baadaye, inapofika kwenye civil liberties, is one of the best drafted provision, Article 18. Nitakuja kuwaonyesha baadaye. Ni kwamba kweli umevunjiwa haki zako, haitakiwi kuzungumza mara moja. Wanatakiwa waipe yule aliyekuvunja mguu muda wa kurekebisha ule mguu. Alafu ndani ya muda, I can assure you, sijafanya utafiti wa kutosha, lakini katika kesi zote za human rights zilizoamuliwa Tanzania, hakuna hata moja imetekelezwa. Nimemsikia dada yangu wa chuo kikuu anafanya utafiti kuhusu utekelezaji. Wewe fanya utafiti kuhusu kutotekelezwa. Utekelezaji hutapata data. Kutotekeleza maamuzi ya mahakama, sio ndani ya nchi tu, hata za Afrika ya Mashariki. Mtikira mpaka kafa hajatimiziwa amri zake. Ni ya Rebeka nimesikia ukizungumza hapo. Kidogo tungegombana na waziri. Nilimtizama waziri alafu mfundisha hii shughuli. Wanafunzi wangu wananiangusha. Muliro na yumo. IGP Wambura na yumo. Mpaka siku nyingine sitakagi kutaja. Na natulia Ackson na yumo. Sasa nikawa najiuliza, Mahakama Kuu ilisema Tanzania marufuku ndoa za utotoni, na ikafuta kifungu cha 13 na 17 cha Law of Marriage Act. Serikali ikakata rufaa ikasema ngoja tukatafute maelekezo. Wakaenda Court of Appeal na wakayapata kweli. Court of Appeal ikaconfirm. Serikali ikapewa muda. Ule muda umeisha mpaka leo hajarekebisha, anasema tunaenda kutafuta maoni ya wananchi. Yaani niliwaambia kama kuna greatest contempt of court decision, it is that decision. Yaani Court of Appeal, which is the highest court in the land, imeshaamua, nyie mnaenda kujadili. That is contempt of court. Bahati mbaya sasa huwezi kumshtaki Attorney General for contempt. Unaweza. Anaweza kafungwa kwa niaba ya serikali. Si ndio sheria inavyosema sasa hivi? Kumshtaki rais, huwezi kumshtaki makamu wa rais, unamshtaki Attorney General kwa swala ambalo halimuhusu. Unaona sheria yetu Alafu ukimshinda anakuambia kwani mimi? Na ukienda naye mahakamani, that's the first PO. Wewe mimi Attorney General ni kuvunja mguu. Ndio sheria yetu. Sasa asubuhi kawa jioni, jopo la majaji watatu wa Court of Appeal wameamua kutengua hivyo vifungu. Wameipa serikali miezi 12. Nyie kaeni mkao wa kura tu, itapita miezi 12 hakuna marekebisho yoyote. Sana sana anaweza akaleta sheria nyingine mbaya zaidi. Ndio kamchezo kamekuepo. Sasa tunaposema procedural certainty na protection ya individual liberties katika mazingira hayo unafanyaje? Unaenda mahakamani ambayo ndio nasema under article 107 capital A ndio mtu mwenye amri, mamlaka ya mwisho ya kutamka kuhusu haki. Lakini that is not the case in our situation. Kwa hiyo Dr. nafikiri katika kufanya research yako uangalie maamuzi yapi ya ndani na nje hayajatekelezwa mpaka leo na what can we do. Alafu lingine, serikali ikatunga sheria ikasema hata ukiibana kwenye shauri huwezi kuattach property yake. So you cannot execute by attaching government property. Alafu ikasema na Attorney General situme kushtaki, you have a right to appeal, na inakuwa ni sawa na notice ya kusitisha execution. Haifollow? An automatic stay of execution. Young lawyers mpo. Ndio mazingira ya kazi haya. Ndio maana watu wengine wanasema ngoja niende na mirathi yangu. Kesi za mirathi tunaenda, wasipolipana shauri yao, mimi nishapata fee. Kwa hiyo tunapata tatizo la kupata young lawyers kwenye public interest litigation kutokana na haya mazingira. Lazima cha kufia ni nini? Naenda mpaka mahakama ya rufani alafu hamna chochote kinachofanyika. Kwa hiyo ukiongeza na ile fia sasa unapigiwa kasimu na wewe ndio unajifanya mzalendo kuliko wengine. Tutaona basi. Alafu hiyo simu namba haijulikani. Kwa hiyo kila siku ukitembea ukisikia tu hata mbwa kabweka unageuka. Utafikiri wamekufuata. Very bad. Aya. Examples za civil liberty ndio freedom of speech, freedom of religion and the right to a fair trial. Na hii kesi inaendelea sasa hivi huko ingawaje hataki kuizungumza, ndio mtihani mkubwa wa the right to fair trial kwa Tanzania. Haipo ile juzi kawaambia wale mawakili wa serikali msinizoe, mimi sio mwenzenu. Mnaniita mwenzenu, mimi ni mtuhumiwa. Ni mshtakiwa saizi mnaniita mwenzenu. Nyinyi nani washtakiwa? Yaani kama kuna burudani hiyo inaendelea hapa. Kuna siku niliendesha kesi ya uchaguzi ya Arusha. Alafu Lissu anamtetea mgombea aliyeshinda ambaye yaani ilikuwa ni burudani. Kila ukiamka kuna PO. Na inabidi uwasikilize ufanye ruling. Nilifanya ruling 10 kabla ya the main judgment. Na kwenye main judgment nikawakomesha. Niliandika kurasa 75. Alafu nikazisoma masaa 3 dakika 45. Nilipomaliza nikanyanyuka nikapotelea kusikojulikana. Wakaenda wakafanya vikao, wanaangalia kaniwia apili, wakakosa grounds of appeal. Wakasema huyu jaji lazima wa chama fulani. The right to privacy. Haifollow? Sasa protection of personal information sasa hivi imekuwa a big problem. Haifollow? You are not sure hiyo information yako unayoshare unayofanya nini itaishia wapi. Na wametoa warning kwamba there is a big brother watching, inaitwa CERT. Yuko chini ya TCRA. Sio kama mnajua kwamba message zenu zote mnazotumiana zinaangaliwa kila kukicha. Wakiona kuna flow fulani hivi, huja mbona anawasiliana na mtu ambaye yuko Iran, unatafutwa. Huko Iran kuna nani huko? Unataka kutuletea nuclear. Wao wako constantly pale. Haivyo? The right to privacy. Na wakati katiba yetu inasema inalinda. Sasa zinatofautiana vipi na human rights ambazo tumeshaye kuzizoea? Civil liberties ambazo nazungumza They focus on protecting individuals from government overreach and the infringement on personal freedom. Ukienda kwa wenzetu Ulaya, Marekani, wana survive kubishana na mahakama. Marekani. Kwamba mamlaka ya serikali yanatokana na wananchi. Lakini how do you exercise it? Kwenye digital democracy, this is possible kwa sababu mnaweza mkawafikia watu wengi kwa wakati mmoja na mnasema iwe na isiwe, hili hatulitaki. Free and fair elections. Si inakuja tarehe 29. Wameshasema tutatiki. Si wao na nani. Na tunahisi uchaguzi wa mwaka huu unaweza ukawa na election petition nyingi sana, zitapitiliza mpaka baada ya matokeo kutoka ya uchaguzi na baadaye. Nilikuwa Dodoma nashirikishana na majaji kwenye namna watakavyosikiliza hizo kesi. Nilipotoka huko tukaenda kuzungumza na mawakili wa
industry.
Unajua misinformation kwa Afrika yani wanaipenda kweli, kwa sababu watu wanapenda umbea zaidi kuliko ukweli. Ukisikia umbea unaufuatilia kabisa. Wakili tena kisha achana na nani na girlfriend wake ndio. Alafu sasa unaenda kufuatilia zaidi, inaenda sasa kwenye taifa, mnakuwa mnapenda. Sasa misinformation pale ambapo mtu anageuza ukweli, uongo unakuwa kama ukweli na watu wanaufuata huo, na media ndio zinakuwa responsible kwa hili. Tulishazungumza nao, tumewaambia jamani, hii misinformation industry inakuwa mpaka kuna watu wana viwanda vya kutengeneza misinformation, because they make money out of that. Sasa a commitment to media literacy na open dialogue itasaidia sana. Lakini hata wewe wakili ukipata taarifa, verify source yake kwanza. Lakini jamaa akitumia kajitu kwenye WhatsApp kisha rusha kwa wenzake, it's a criminal offense kurusha information ambayo italeta hate speech, italeta kutoelewana na watu. Watu wangapi mkishapata taarifa tu umeshakarusha? Na sasa hivi wakati huo uchaguzi zitarushwa hizo taarifa nyingine mpaka za matusi na nini against mgombea mwingine. Haifore? Ndiko wanakotafuta na AI inasaidia sasa hivi. Kichwa cha msemaji kiwiliwili sio chake. AI ni balaa. Kuna wakati hapa sio, mnamkumbuka mtu mmoja alikuwa anaitwa Ditopile Mzuzuri. Mnamkumbuka? Ilileta tabu. Wake walichapisha taarifa zake anajivinjari na mdada. Alafu baadaye ilikuja kumkumba kashfa moja very bad. Kagombana na dereva wa daladala. Kashuka kwenye gari kamshona risasi. Haifuri. Kesi yake ikaenda, bahati nzuri Mungu akaamua kuimalizia. Akafariki dunia. Si mnajua tena under the criminal law, when you die the matter abates. Lakini alileta shida mpaka mahakamani. Kwa hiyo sasa taarifa hizi za uongo kama zinamuhusu mtu maarufu, yani zinasambaa haraka sana, na unaweza ukamdhalilisha mtu. Sasa mawakili unaweza kuwa na hiyo digital defamation na ikawa mbaya sana kama wewe ni source. Na kuna kikosi kinaitwa kikosi cha kufuatilia mambo ya ajabu ajabu mtandaoni. Si mnakijua? Kiko chini ya maaskari wa polisi. Protection of journalists and the media. Another thing ambayo sasa hivi inatokea, wote tunategemea media na journalist kutuletea taarifa. Na kwa taarifa yenu, definition ya journalism imepanuka sasa hivi. It includes bloggers. Hata wewe ukiwa blogger, ingawa sasa hivi unatakiwa upate leseni, you are a journalist kwa sheria za Tanzania. Kwa hiyo wanakuwa wanatishiwa kama nyie mawakili mnavyotishiwa mnaposikiliza kesi za civil liberties. Journalist safety yao na iko mashakani sana. So na wengine wamehama nchi mpaka leo hajarudi, si ndio? Kwa sababu hiyo ya hiyo threat. Na bahati mbaya sasa kesi ya criminal huwa haifi. Siku yote ukionekana tu wanaikumbushia. Kesi moja tu ya criminal huwa inakufa, ni ile ya murder attempted. Kama ulitaka kuua mtu lazima afe ndani ya mwaka moja na siku moja. Akifa baada hapo hujahusika. Sasa hii yote nilikuwa nazungumza, basis yake ilitokana na Universal Declaration of Human Rights na Civil and Political Rights. Si mnaona Universal Declaration ilikusanya haki zote, civil, political, economic, social and cultural. Lakini Covenant on Civil and Political, si mnaona ika narrow down on civil and political. Kwa hiyo zile civil liberties ziliingia kwenye hiyo covenant ambayo ni binding na Tanzania imeratify na ina protocol zake 2, lakini Tanzania imegoma kuratify moja, ile inayokataza adhabu ya kifo. Lakini bahati mbaya hatuna moratorium, lakini kuna watu wapo kwenye death row mpaka leo hawajui hatima yao, zaidi ya 600. Na Tanzania ukitaka kuhakikisha kwamba umekuwa jaji uliyekamilika lazima uhukumu mtu kunyongwa, si ndio? Nani ameshashika kesi ya mtu kunyongwa? Anyoshe mkono. Ulienda kulala siku hiyo baada ya adhabu kutolewa? Maana ndio adhabu peke yake. Wanaposema haya anakaribia kutoa adhabu, wote mahakamani mnasimama. Nasema sheria inanipa adhabu moja tu, mikono yangu imefungwa, utanyongwa hadi ufe. Maana ukisema utanyongwa tu unaweza asife. Mimi kesi niliyoshika, sasa nataka niwaambieni kwamba hizi civil liberties simesema kwamba za kwako na hiyo ni sawa sawa. Sasa unatolea mwenzio kifo, wewe unabaki na uhai kweli? Serikali inajaribu kuingia kwa niaba ya victim. Watu wanakelele sasa hivi kwamba ifutwe, lakini I can assure you, niende kuwauliza wale ndugu zake na marehemu watakuwa kama sasa. Kwa hiyo kuna hilo tatizo. Sasa Republic of Tanzania ambayo ina nchi ngapi? Dada, the United Republic of Tanzania ina nchi ngapi? Hujui ina nchi ngapi? Wewe umetokea wapi? Komoro? Dada, umetokea Komoro? Hujui Tanzania United Republic ina nchi ngapi? United Republic ina nchi 2. Ina nchi inaitwa Zanzibar na nyingine inaitwa Tanzania mainland ambayo zamani ilikuwa inaitwa Tanganyika. Kila siku nawaambieni watu hawasomagi katiba hizi 2. Katiba ya Jamhuri ya Muungano ya mwaka 77 na katiba ya Zanzibar ya mwaka 84 ilivyorekebishwa 2010. Katiba ya Zanzibar inatamka Zanzibar ni nchi ndani ya Tanzania. They are very specific. Na mpaka sasa hivi wamebaki na kitu kimoja tu, wawe nchi kamili. Ina rais haina, anaitwa rais wa Baraza la Mapinduzi, si ndio? Ina bendera haina, ina bunge haina, ina serikali haina, ina wimbo wa taifa haina. Wengi hawajui Zanzibar ina wimbo wa taifa. Amkuwa mjui na nyinyi mnakaa Tanzania, kweli nyie kiboko. Zanzibar ina wimbo wake wa taifa. Yes, the only thing they don't have ni sarafu yao na uwezo wa kuingia kwenye mikataba ya kimataifa, lakini wanaingia hivyo hivyo. Ikija FIFA wamo. Sema mnatuachaje sisi? Na hii walifanya makusudi kwa sababu ilikuwa inashaanza kuleta shida. Sasa imegundulika gesi na petroli hapo ziwani, hapo baharini, tutaanza ugomvi upya. Kwa sababu kuna kitu kinaitwa 200 nautical miles, yani economic zone. Utakuta na Zanzibar hii muhimu ndani, sasa tuna ugomvi. Lakini the United Republic of Tanzania ninayezungumza kwa nyinyi hapa na maana watu wa bara. Kwa sababu ndio sisi peke yake tulikosa serikali. Zanzibar wanayo. Kwa hiyo ambao wakipaswa kulalamika kudai serikali 3 ni sisi wa bara, sio wale. Wale sio wana serikali, nyinyi imekula kwenu tangu 64, mnashangaa tu. A nation without a named territory. Zanzibar wana Mzanzibari. Tanganyika definition ya citizenship ni waliokuwepo kabla na baada ya uhuru. Kila Mzanzibari ni Mtanzania, lakini sio kila Mtanzania ni Mzanzibari. Na Mtanzania hawezi kumiliki ardhi Zanzibar, lakini wao wakija hapa wanamiliki ardhi na wanawake zetu. Article 3 ya katiba yetu inasema Tanzania is a democratic, secular and socialist state. Ile socialist bado wana ugomvi na ina adhere to multi-party democracy. Sisi hatuna multipartism, tuna vyama vingi vya siasa. There is a difference. Kwa sababu there is no democracy which is being practiced among those 17 plus. Hata hicho chenyewe kikubwa. Simeona juzi walikuwa wanataka kushikana mashati hapa. Rais kapatikana, mgombea wa rais kapatikanaje. Nilifikiri tutazungumzwa kwa wale wa upinzani, kumbe na sisi tumo. Why we are not following democratic principle, even intra-party? It's a serious one. Article 8, it talks about tunafuata principles za democracy and the social justice. Social justice is a concept of the of the Eastern Europe. Lakini sisi tuachane na hiyo ya social justice, tuende kwanza na principles za democracy. Principles za democracy ni pamoja na kupiga kura kuchagua viongozi wetu kila baada ya kipindi fulani. Na sisi tumeamua ni miaka 5. Kura ya siri na ni mchezo wa watu wazima tu, sio watoto. Kwa sababu sheria yetu inasema kila Mtanzania, na ni Mtanzania tu, raia, sio mgeni, ana uwezo wa kupiga kura. Tanzania hatuna electronic voting system. Si mnajua kama ingeingia hapa kingetokea kitu gani? Ile huwa haidanganyi. Sio easy kuiba. Ukishapiga imepiga na ina register everywhere. Asa nani ataikubali hiyo? Tulijaribu biometric registration, mliona kazi yake. Zile mashine bwana hazikubali mikono ya watu sugu. Maka zimetengenezwa kwa ajili ya wazungu. Sasa wewe ndugu yangu huko umelima viazi huko, hata ile finger print zimeshakwama. Hata ukikamatwa na polisi hawezi kujua what are the fingerprints. Peleka biometric inasema it cannot recognize. Ikabidi warudi kwenye manyo. Walinunua mashine nyingi, tusimeishia wapi? Tumeenda kuregister mle ya kizamani. Lakini la muhimu ni kwamba mamlaka ya serikali yanatokana na wananchi. Hii ndio ile principle alikuwa anazungumzaga Kennedy, government of the people, by the people, for the people. Ipo na Chadema ndipo walipochukua hapo ya people's power, I don't know. Sasa hiyo ndio katiba yetu. Hili swala la rangi ya katiba nalo ni politics. Si mnajua? Katiba ya 1977 ilikuwa na rangi ya kijani. Na kwa sababu ilitengenezwa na kamati ya chama kimoja iliyokuwa inasimamiwa na Pius Msekwa, watu walipofika kwenye multipartism 1992 wakaitama hii rangi ya chama fulani. Wakasema isiwe shida, basi tutaweka rangi ya majilio. Rangi ya majilio ikawa asubuhi ikawa jioni, ACT Wazalendo wakajitokezea. Sasa sisi tutaweka rangi ipi sasa? Nafikiri ikija tena itakuwa white, neutral. Sasa hii ndio ameweka hizo haki pamoja na hizo freedoms. Sasa pamoja na kuwepo hizo haki, niliwaambieni rights are not. Kwa hiyo kuna limitation za aina mbili kwenye katiba yetu. Kuna hii moja inaitwa omnibus limitation au clawback clause, na ile iliyo under, of course nimekosea, sio article 30 sub article 2, alafu general limitation on judicial role and 30 sub article 5. Naomba mrekebishe. Ile ya general limitation ndio ile nilikuwa naambia kwamba inasema serikali haifungi kwa hizo article zenu mlizoweka humo za haki kutengeneza sheria nyingine yote ambayo kwa maudhui yake inaonekana kama inakiuka hizo sheria. Na ndio maana sasa hivi wameweka huo utaratibu wa kutunga sheria hizo ambazo tutakuja kuziona za kuzuia haki ya kufurahia freedom of expression. Lakini kuna article 107 judiciary kama final say na article 30 sub article. Lakini vile vile article 30 sub article 3 kuna hii haki ya kudefend your human rights, ambayo ndio watu tulikuwa naitumia mara nyingi kwenda nayo mahakamani, inaitwa personal interest litigation. Na zamani kabla hawajatuvuruga na Bradea, mtu alikuwa anaweza akashtaki kwa niaba yako. Lakini baadaye wakaja kutoka na hii kitu inaitwa affidavit ya admissibility. Lakini kuna the duty to defend the constitution and the laws of the land. Hii iko under article 26 sub article 2, ndio inaitwa public interest litigation provision. Na ya mwisho ni innovation mpya ambayo imejitokeza ili kupambana na hii vurugu za kutuzuia kutumia hizi mbili. Wamekuja version ya kutumia article 108, inatumia inherent powers za high court kwa jambo ambalo ingeweza kuwa na mamlaka nalo. Na walishapeleka several cases, na hii kesi ya juzi iliyokuwa na question mamlaka ya hiki kifungu ambacho kinasema mahakama itatumia tradition yake na inherent power zake kuamua jambo ambalo linaweza likaamuliwa chini yao. Kwa hiyo mawakili vijana, tuna hizo innovation. Huna haja ya kuogopa ni kifungu kipi utakitumia kwenda nacho mahakama. Ni innovation. Ukiziba huku, they go there for another innovation. Kwa hiyo tumefanya hivyo na mahakama zimekubali. Sasa hivi ninaona there is light at the end of the tunnel. Mahakama zetu zimeamua kurudi kwenye busara zake za zamani. Si mnakumbuka kuna wakati human rights jurisprudence hapa ilikuwa imepamba moto. Na wakati ule alikuwa jaji mmoja tu ndio maarufu anaitwa Marusanya, mpaka court of appeal walipomwambia kwamba wewe you are becoming like an ambulance chaser. Yaani ukipigania haki. Cha ajabu ni kwamba mahakama majaji wanaoneana wivu wenyewe kwa wenyewe, which is very strange. Wale tuliwaambia watutunzie kuku, wanaamua kuwala wale kuku. Commercial break. Bado na muda gani? Maana mmekaa mmesikitika sana. Sasa bwana, kulikuwa na mtu mmoja anaitwa Rafaeli. Rafaeli alikuwa ni mtumishi wa parokia. Si mnajua parokia? Na alikuwa anaangalia kuku wa paroko. Lakini